Welcome to Michigan Condo Voices, where real co-owners and real Michigan communities come together. We break down the issues that matter most with clarity and transparency. Let's get into today's episode.
Hi everyone, this is Stephanie from Michigan Condo Voices. If you own a condominium in Michigan, there's one law that quietly shapes your rights, your responsibilities, and how your community operates. It's called the Michigan Condominium Act. Most co-owners have never read it. Most board members rely on professionals to interpret it. But understanding the basics can change how you see your community. Let's break it down in 5 minutes. The Michigan Condominium Act is the state law that governs how condominiums are created, managed, and regulated in Michigan. It establishes how a condo project is formed, what documents control the community, the authority of the board of directors, the rights and obligations of co-owners, and assessment powers and financial responsibilities. It applies to nearly every condominium project in the state of Michigan. Your bylaws and master deed must comply with this act. Under the act, every condominium must have a master deed, bylaws, and a condominium subdivision plan. These documents define common elements versus limited common elements, maintenance responsibilities, voting rights, assessment structures, and insurance obligations. The Act provides the legal framework, but your specific documents fill in the operational details. If there is a conflict, state law generally prevails. The Act gives the Board of Directors significant responsibility. Boards are authorized to collect assessments, maintain common elements, enforce bylaws, enter contracts, and adopt rules and regulations. But that authority comes with duty. Board members are expected to act in good faith in the best interests of the association and with reasonable care. The law assumes stewardship, not control for control's sake. One of the most important components of the Act involves assessments. Co-owners are legally obligated to pay regular assessments, contribute to common expenses, and support reserve funding where applicable. The association in turn must use funds for maintenance, repair, insurance, and administration of the condominium project. Financial transparency is not just a best practice, it is embedded in the governance structure envisioned by the Act. The Act allows associations to impose fines if authorized in governing documents, enforce compliance through legal means, and place liens for unpaid assessments. At the same time, co-owners have rights too. Co-owners may access certain association records, vote in elections, amend governing documents under specified procedures, and challenge actions that may not comply with governing documents or state law. The Act does not eliminate conflict, but it provides structure for resolving it. Many issues in condominium communities are not personal, they are structural. When co-owners and boards understand the Michigan Condominium Act, conversations shift from emotion to framework. Instead of, why are they doing this? The question becomes, what does the governing structure allow and what does it require? That's a more productive starting point for everyone. If you live in a Michigan condominium, you don't have to memorize the statute, but understanding this foundation helps you ask better questions, participate more confidently, and recognize where authority begins and where it ends. The Michigan Condominium Act isn't just legal language, it is the operating system behind your community, and awareness is the first step toward transparency. Take care, everyone. Thanks for listening.